Hello and welcome to another Me RIT webinar. This virtual event series was created exclusively for RIT alumni through the RIT for Life commitment to your continuing professional and personal education. I'm Cindy Soberay, Executive Director of Marketing and your moderator for today's webinar. Before we start, let's take a moment to ensure that everyone is ready and familiar with the presentation tools. All participants in today's webinar have joined in mute mode and cannot be heard during the presentation. However, we absolutely encourage your participation. To submit your questions at any time, please enter them in the chat box. The chat box can be opened by clicking on the chat icon located at the top right if you are a PC user and the bottom right for you Mac users. If you are unable to locate the chat box, please follow the link provided on the slide for more information. We will make every effort to address all your comments and questions at the end of today's presentation. If you are viewing the webinar in full screen mode, please note that you will have to return to the traditional screen view to access the chat box. Today's webinar will be recorded and made available, complete with captions, within a week following today's event. All participants will receive an email with a link to the recording. If you have any technical questions, please feel free to type those into the chat box and we will do our best to get you the appropriate answers. And with that, I'd like to introduce today's webinar titled How and When to Protect Your Ideas. Our presenter today is Dale Davis, a 1996 alumnus of the Kate Gleason College of Engineering and Executive IP Counsel for GE Power's Gas Power Systems business. Sorry, that's a mouthful. Dale manages a massive and complex international IP portfolio that includes roughly 15,000 patents. His stewardship is critical to gas power systems achieving financial and strategic goals. He works across a varied product portfolio of gas turbines, steam turbines, electric generators, and other power plant technologies. He is also a critical leader on business strategies, M&A transactions, IP investigations, licensing, invention development and protection, sourcing of IP-sensitive components, joint ventures, joint developments, and employee matters. Dale began his GE career as an international technical advisor with resident assignments in Europe, the Middle East, and North America. He later accepted a role as lead engineer in advanced controls development. Dale left GE to attend North Carolina Central University School of Law on a full scholarship. Upon graduation, he was an IP associate with Moore and Van Allen in Research Triangle Park, North Carolina. Dale is a member of the United States Supreme Court Bar, State Bar of North Carolina, and he is a registered patent attorney. In 2006, Dale returned to GE as patent counsel for GE Energy in Atlanta, Georgia. In 2011, he is promoted and promoted again in 2014 to his current position. Dale has been awarded 9 patents and is recognized as an expert in intellectual property law. He's lectured and discussed IP to a wide range of organizations. In 2014, he was named a GE Legal Icon. Dale is passionate about diversity and community service. He serves as the AAF Business Champion for GE Power, is a leader in street law, and a United Way leadership giver. Early achievements include a distinguished military career in the United States Army Reserves, holding leadership positions in the infantry and civil affairs. We are very, very fortunate to have Dale with us, and in fact, he is actually here in Rochester joining us this week. So Dale, welcome, and it's all yours.
Well, thank you very much. After listening to that, I hope people don't realize I'm not as old as that sounds. We've just been busy for the past 2 years, or I guess 2 decades or so, since we graduated from RIT, and it's an honor to come back and serve and to be amongst old friends and so on. And I'm very passionate about intellectual property. I really want to focus on it today from 2 different aspects: how to protect it and when to protect it. So with respect to an agenda, we'll talk about the IP basics, spend some time on strategy, and an overall communication from the standpoint of what should you say or not say when you have some ideas and you want to talk about those ideas externally to customers, suppliers, or others outside of your organization. We hope to make this as interactive as possible, so please feel free to send the questions in and we'll try to answer them. If I don't know the answer, I just will ignore it. No, I'm just kidding. If I don't know the answer, I'll make sure to follow up with you through an email or through whatever means available. When we think about intellectual property, first we should probably ground ourselves when we think about just the overall concept of property to begin with. The law recognizes, and the form of the recognition is different through different countries, but essentially the law recognizes property as what we call a bundle of rights. Okay, when you have a piece of property, either real property as in land, personal property like your watch, which we also call chattels, or something intangible property like patents or an interest in stock or so on, what can you really do to say, I have that? You could prevent others from using it. You could sell it. You could use as collateral. So these bundles of rights are what the law recognizes. And those same bundle of rights apply to various forms of intellectual property. As you say, real property, personal property, and tangible property. So you have a property right if you could prevent, you have an interest and you could prevent others from the unauthorized use or taking of it, what we call an infringement. So what is intellectual property? Okay, again, it's a subset of property. It begins and it's a product of the human mind or intellect, right? And it's recognized in the law as a right. So just for example, when we think about, for our American audience here, when we think about the United States Constitution and we think about the original articles, okay, in the United States Constitution, the framers specifically, in Article 1, Section 8, Clause 8, laid out the rights for patents. That should give you an example. It actually also lays out copyright. That gives you an example of just how important intellectual property rights to the framer of our great country. So there's 5 forms of intellectual property that are recognized. There's patent rights, trademarks, trade secrets, copyrights, and mass works. These are all different forms of intellectual property. If you take anything away from this talk, it is this. One idea or one invention can be protected by multiple forms of intellectual property. So just because you have a patent on something doesn't mean you may not also be able to get a trademark on that same thing or some variant thereof, okay? IP is originally owned and initially owned by its creator. And like other forms of property, you could sell it, it could be lost, you could lose it as collateral, it could be given away, it could be abandoned, it could be stolen. And because of that, it must be protected. So you always want to be thinking about, how do I protect what I'm creating, okay? So we'll talk about patents, and I'll probably focus a lot of the IP basics around patents and trademarks. I work for a technology organization, and for us, those are probably, patents and trade secrets are probably the 2 big areas. Now in the digital age, industrial, digital, Internet of Things, we're doing more with copyright and software protection. We'll talk about that as well. So what is an invention, okay? It's a product of the imagination, right? If you look up Webster's. For the legal ones amongst us, you'll be familiar with Black's Law Dictionary, okay? It's a concept, a process of contriving and producing something, okay, that was not previously known or in existence, okay? The key takeaway here is that just because you have an idea or you have a design, it does not equal an invention. There has to be some development work. So for example, I have this idea of curing cancer, okay? I want to cure cancer. That's my idea. That's not an invention. Now, if I developed that and I did some research and did some work in an analysis in a lab and so on, and I figure out a way to reduce the instances of certain forms of colon cancer by using some cocktail of medicines and exercise and all these other things, and I do that in a unique way, Now I have an invention. So what's a patentable invention? Okay, any new or useful process, machine manufacture, composition thereof, or, and here's the key part, any improvement thereof. Most of the patents that you see, and I think right now there's probably in existence just under 10 million patents, and I wouldn't be surprised, U.S. patents, and I wouldn't be surprised if by the end of this year that we break the 10 million barrier, okay, which will be a significant milestone for our country. Most of those patents are incremental improvements of other patents. A big fallacy I've seen over the years, and I've been doing this for a while, is that most people think that they have to have this new great idea, new way to slice bread, something to replace the wheel and all these things. Most valuable patents that you see are improvements over other things, okay? Discoveries of physical principles and mathematical algorithms may not be patentable. However, uses of those things are. So say, for example, we all know gravity, right? Gravity is something that occurs naturally, it's a natural phenomenon in nature, right? You can't patent gravity. However, you can patent uses of gravity or a way to prevent gravity or stop gravity. Think about a plane and all these things. A plane, the way it's combusting air and fuel and all these things, is doing it in a way with thrust to overcome the effects of gravity so that when you're in the sky you don't fall straight to the bottom. Okay? And those things obviously are patentable. So again, what do they cover, what don't they cover? Okay? Inventions, new and useful process. So from a pure legal perspective, right, inventions are covered in Title 35 of the United States Code, so we call it 35 USC. 101 means it has to be new, something different, or useful actually, right? 102 means it has to have some sort of aspect where it's someone else didn't create it, and so on, right? 103, which is really an area that we spend a lot of time on, is obviousness. If I create something, it has to be so different that someone who's also working in that area, okay, what we call a person having ordinary skill in the art, would not have naturally come up with that anyways. Okay, so years ago the case law used to require this flash of genius, but essentially it has to be something that is new and useful, and something that the average person working in that area would not have come up with on their own. Okay. Again, computers that implement algorithms and programs, right, that are tied to a particular machine or transform an article into a different state, those may be patentable. And we'll talk about software a little bit, but I'll just give you a precursor. In most jurisdictions in the world outside of the United States, software is not patentable. In the United States, software is patentable, but you want to draft your patent application or have someone draft a patent application for you in a way so that it's tied to some physical transformation, doing one thing for another, not just crunching data, these sorts of things. What don't patents cover? We talked a little bit about physical phenomena, gravity, fire, all these things, laws of nature. Natural objects, unless isolated from their form. This is really getting into DNA and these sorts of things. Abstract ideas, music, photographs. When we say code, software code. Okay? Now again, just because they may not be protected by a patent doesn't mean they're not valuable, doesn't mean it's not useful, and it doesn't mean it can't be protected by another form of IP. When you think about abstract ideas and music and photographs, copyright, copyright protection, or weird squiggly lines that might be trademarked, and all these sorts of things. Still valuable, still useful, and it's still protected. Okay? Trade secrets, what they cover, what they don't cover. Okay? Information that brings you or your organization some competitive advantage that's not known to the public. Think of grandma's recipe for something. Okay? If that recipe is valuable, chances are you're probably not going to patent that recipe. Let's expand on that a little bit, okay? Think about the Coca-Cola formula, which came out, was invented, created in the early 1900s, okay? That's a trade secret, one of the most valuable trade secrets, okay? If Coca-Cola would have patented that recipe, the patent would have expired. The life of a patent is roughly 20 years. So by maintaining it as a trade secret and by getting that economic value and a competitive advantage, you're able to keep the life of that trade secret forever. Every so many years, maybe 10 years or so, Coca-Cola will go on its big blitz, right? They're moving the Coca-Cola formula from this vault to another vault. Why are they really doing that? They're continuing to show the world that they're doing all that they can to protect that formula from leaking. A big concern with trade secrets is employee theft and corporate espionage and all these sorts of things. So you have to take reasonable steps based on the value of the trade secret to maintain its secrets. And we use trade secrets all the time. You may not realize it. Your formulas, business methods, any customer list that you have, any phone directories, and so on and so forth. Okay. But what don't trade secrets cover? Okay. Information that's generally known to the public. Okay. Information that you could easily figure it out, find out. Okay. And again, information that doesn't provide a competitive advantage. If I have a recipe on how to make bread, okay. Now, just so you know, I'm not a baker. I know how to eat bread, okay? But just so you know. But if I did, and my bread is lousy, it's terrible, and no one will buy it, and someone steals my recipe, I don't have a trade secret case because no one's going to buy my bread. No competitive advantage. So you have to have something that brings an economic and a competitive advantage, okay? So let's talk just a little bit about software in multiple forms, especially for us. I work for an industrial conglomerate, and for us, we're GE Digital is relatively new. Now, we've always done things with software and so on, but now it's much more at the forefront of our company. So when we think about how do we protect it, right? Again, you can protect it with multiple ways. We could patent how the method of how the software is used, right? We could keep as trade secret the quote-unquote secret sauce of the algorithm. We could copyright the code itself, and we could trademark. Like say we have one of our trademarks, or maybe OpFlex, or some sort of fancy little squiggly lines, or right associated with the idea itself. Okay, a single piece of software can be protected by multiple layers of IP. Okay, I use software as an example, but really other inventions as well. Software is something that we could easily think about, but other inventions as well can be protected by multiple forms of IP. Okay. Again, software-related patents are patentable in the United States if it's claimed properly. Right? We use method claims, system claims, and also what we call Beauregard claims. Now, there has been a lot of Supreme Court case law around intellectual property in the past few years, which is really good. There was a recent case called Alice that really, sort of are making our practitioners think about how we approach this matter. But at the same time, the conservative rule of thumb is to tie your software to some sort of physical transformation of something. Now, outside of the United States, it's different. Software patents they may not be considered what we call patentable subject matter, or extremely hard to get. Okay, it can't be a business process. Okay, and most patent offices across the world, they just don't recognize it as media claims. Okay, So again, software per se is not patentable, but the process performed by the software, the system running the software, and the media that contains the software may be patentable, okay? U.S. is the most liberal. Now, another area when we think about intellectual property and software is the use of open source software. It comes with risk, okay? And you really want to be thinking about this free software and this whole community of everyone's kind of, I don't want to say crowdfunding or crowdsourcing, but everyone's kind of contributing to its development and its betterment and all these sorts of things. That sort of sounds great, but there's risks, okay? First, you have to disclose what you're doing, right? And if you use open source software and you tweak it a little bit, it'll be really hard for you to try to commercialize it because it's free. You got it free, you made it change, and now you're saying, well, wait a minute, my change creates an economic value. I want to sell that. Now, you may be able to sell services related to the open source software, but it gets real tricky. It might be very hard for you to license. So if I create a piece of software and I want to license it to others and create a stream of income, that might be hard to do. And there's just a lot of uncertainty in this space. And the next generation of software, of open source software licenses can be very so we just had this scale. Depends on the type, you know, of risk, like a GPL, LPL licenses tend to be more riskier. I think that most common use tend to be Apache and Mozilla, but you just have to be really, really careful. Like within my organization, we have different scans, and we have a whole team of experts associated with this open source software. And in the mergers and acquisitions context, one of the things that we almost always require when we're buying a company, irrespective of its size, it could be $10 million business, it could be a multi-billion-dollar business, is that an independent search and scan for open source software is done, so we don't have any surprises, because we want to commercialize what we're buying. Okay, so just something to keep in mind. I'll talk really quickly about patents and their claims. So when you look at a U.S. patent, or any patent really, the most powerful aspect of the patent is what we call the claims. And in the U.S. patent, it's in the section at the end. Think about it this way. When you buy a piece of property, you have a deed. The deed lays out what we call the metes and bounds of your property, and it'll have all this kind of, you know, language that's not normally used. So from the northwest corner, go so many 100 feet to this point, and then from that point go maybe 10,000 feet to another point, and so on and so forth. Those are the metes and bounds of what you just bought, right? That lays out, you know, the scope of what you're buying. But when you first find out about that piece of property, it's not going to be described that way. There's going to be some sort of listing, like the multiple listing service, an MLL listing. Oh, this is a beautiful piece of property with lakefront views, and blah, 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 all these sort of things that described what you're buying. But from a legal perspective, the strength is what that claim is. Like, you know, I guess when the quote-unquote Western part of the United States was acquired, however you want to look at it, people laid claim, right? They'd have these horse and buggies that would go out and they would lay these stakes down. They're laying a claim to the land that they want. It's the same thing in the patent world. That's why we call them claims. So it lays out, it legally describes what your invention is. And there's different ways of doing these claims. There's software invention. You can do a method claim, either how are you going to use this invention, a system claim which lays out the different components of your invention. And if it's a computer product, if it's a piece of software that you want to sell, what we would call a computer product claim, we would basically say, here's, you know, the algorithm A, B, C, D that will be provided on CD for you or downloaded for you, and so on and so forth. The second thing I want you to really remember is that if you're ever an inventor or if you're ever just involved with patents, make sure you feel comfortable with what the claim language says. Everything else in the patent is going to describe the claim language. So there may be figures and images. There's going to be what we call a summary of it. There'll be a description and so on and so forth. But all that does is support what the patent claims. Claims, again, lay out the metes and bounds of your invention. Very, very important. Okay? So here's a chart that I think just gives a good overview of the major forms of intellectual property that we covered in the beginning. Patents, copyrights, trademarks, and trade secrets. You could see the subject matter, right, how long they can last. Is it on the examination required part of it? Certain forms of intellectual property must be approved by some sort of government agency. In the United States, both patents and trademarks are reviewed, what we call examined, by the United States Patent and Trademark Office, uspto.gov. Copyrights are handled by the Library of Congress. Trade secrets have no examination at all. Again, it's a secret, right? It's something that you keep, has an economic value, and you have to maintain it, okay? Now, there's pitfalls. The best part about a patent is exclusivity. It gives you the right to exclude others for about 20 years. But at the end of 20 years, anyone can do it. Take pharmaceuticals, for example. When certain pharmaceuticals come off patent, you'll see a whole line of generics out there, a whole line, like just the next day, right? And so you want to be thinking about the life of the product or the service or the system that you want to patent and whether or not it's going to have a cycle where it will be outdated, right? A new version comes or these sorts of things, okay? You also want to think about whether or not it's going to continue to have value. So in my role, I oversee a very large patent portfolio, which is very costly. So every so many years, we get the team together and we say, okay, we have all these patents in Russia or Brazil or wherever. Do we need to continue to keep those patents alive? Because if not, we will probably just dedicate them to the public or we'll try to license them to someone else because it's costly and so on. So switching gears a little bit, we're just going to talk a little bit about strategy and some of the things you and your teams want to be thinking about whether or not you file a patent, okay? The value of the invention, and you have a problem and a solution that equals your invention. It's valuable if someone wants to steal it. Infringement really is the unauthorized use or taking of it, okay? It's valuable if it excludes others from entering the market without your okay, i.e. without your license or approval or something like that. And it's also valuable if in some way you could monetize or quantify how it adds to your bottom line, okay? Again, it's little value if no one cares. I mean, if you just want to have a patent just to say you have a patent, it's a very great thing, and the patent office will take your money. But if you feel that there may not be a way or you don't have some broader business strategy from getting a patent, you may want to rethink it, okay? And the value is also questionable if you can't tell if someone is infringing on it, if someone is using it without your okay. So detectability is also an important aspect in these matters. So when we think about the value of an invention, we look at a few different overlapping spheres. Is it going to give us a competitive advantage? Can we detect it? And is it somehow going to tie in with our overall corporate profits? Okay. Again, these overlap, and there's times where we're just doing purely a defensive play. It's purely we're filing patents to keep others out of the broader space. Or there's times when it's an offensive strategy. We're filing patents to get into an area that we know we're trying to wiggle our way into. And most often there's both an offensive and a defensive strategy. And as these strategies change, you want to take a look at your IP strategy as well. So how do you come up with these patents? Like, well, where do you start? Okay. One way to look at it is look at the overall goals of your organization. What are what we will call a blueprint? So if your company has a product catalog, you sell, say, 10 items, and those 10 items bring value to your organization, you should probably have either an overarching strategy to all those 10 items, but you also want to have nuanced strategies to each 10. It could be that items 1, 3, and 7 are only going to be in certain markets. So in those markets, you would file patents, and not in other markets, okay? Ideas could come from different levels of the organization. So if we're going to come up with something, hypothetically, a brand new car, right? That's probably going to be a top-down decision. We're going to come up with the new model YZ or whatever it is, right? So the business leaders say, we're going to spend all this research and development dollars on this new thing. You probably want to be protecting that pretty strongly. Also, there's a bottom-up perspective. It could be the team of engineers and scientists and so on that work in the field that engage with the customers, your sales forces, so on, may provide some feedback and some that says, hey, you know what, our customers want this. Can we develop that solution? If you already know there's a market for it, you should probably be thinking about an IP strategy there too. It's all about coming up with some sort of commercial advantage. Okay, you want to focus on, again, your operating margins, the quality of the inventions, and enforcement. Ask yourself, what are my competitors doing in the same space? Okay, what are they patenting? Again, with a patent, 18 months after a patent application is filed, it becomes public record. So you could find out what are your patents. You could try and look and discern if one of our competitors is filing multiple patents in this space, they're probably going to be coming out with a product or service in that space. What is your technology roadmap and what's their technology roadmap? And what areas, where what we call the intellectual property white space, what areas are still fertile? In other words, if you look at a whiteboard and you write down where all the patents are, and you subdivide that whiteboard, if you see a part of that whiteboard that's open, maybe you want to file some patents there, okay? Collaboration is the key when it comes to getting patents. It really is. You want to make sure that you carefully select who you invent with, and you also want to make sure that the folks who you invent with bring different skill sets to the table. Okay? I'm a mechanical engineer by training, and my professional work as an engineer has been in control systems. Well, some of the patents that I invented, where I'm a named inventor, I have folks, material scientists, electrical engineers, folks who just do fundamental research, and folks who work in field services. All these different sort of feedback and all these different sort of collaborators challenge your idea, they strengthen your idea, and overall they make for a better patent, which will make for a better product. Okay? Think about the path from product to service, and think about the IP space you want to defend. So IDL is an invention disclosure letter. So before you file a patent with a patent office, you want to clearly articulate what your invention is. And it could be you have 4 or 5 different invention disclosure letters, and you figure out, you know what, maybe we could combine some of these, or maybe we need to build it out, and so on. But again, try to tie it to some product or service that is going to give you a competitive advantage. That's the name of the game. So when we think about innovation as a whole, it's really an evolutionary process. It's not a static process. Not if you want to stay in business for over 100 years. There's stagnation. This is where corporations, companies, startup companies, whoever it is, they feel that they got it like that. They feel like, well, we have the market. We don't have to innovate anymore. People are buying our things. Organizations like this tend to avoid change, and they're always in catch-up mode, but sometimes it's just too late, right, inactive. Think about network television, for example, right? Growing up, there was 3 channels. You had ABC, you had NBC, you had CBS, and maybe you had some sort of local channel that no one really watched, right? That's what there was. And the big networks were very comfortable. Boom, then you had closed-circuit TV. Boom, then you had cable TV. And then all of a sudden, those 3 networks, they wanted to be part of the game, i.e. AT&T, DirecTV, and all this stuff now, right? Let's fast forward more recently. Then cable TV, they were very comfortable. Then you had this weird, funny thing called satellite, right? 500 channels and all these sort of things. Let's fast forward even more recent. Then you had YouTube. Why did you need all these sort of professional, quote-unquote, actors and so on? People would just make their own content. There's people right now as we speak who that's all they do is make content for YouTube, right? Let's fast forward even to today. In my house, we're cable cutters. We recently cut. We don't have cable anymore. When we want anything from a network, we just stream it. What's my point? If you're inactive and if you're resistant to change, a disruption will come without question. You can't be insular with these things. You have to be externally focused. So what some folks do, or some organizations do, they imitate. Now they're in reactive mode because their profit margins are going down. They have to lay people off. They have to close factories, all these sorts of things, right? They're trailing the industry leader, right? And to survive, they have to imitate. Where do you want to be? You want to be an innovator. You want to be proactive. You want to be thinking not arrogantly that the customers are going to come to you. You have to be thinking about what do the customers really want. And it's really a matter of perspective. Are you internally focused or are you customer focused? Because at the end of the day, customers are going to keep your lights on for you. No matter, you could be your own business person or folks that have their own business. Unless you're in a business where you have yourself as your only customer and you pay yourself, you're going to have to make sure you focus on something else, some other organization or so on. That's just the name of the game. Or that's what I've seen in my decades of experience. Okay? Here's a critical distinction, and we kind of leaned on this earlier. Okay, the difference between an idea and an invention. Okay, again, the idea is I want to cure cancer. I know there's a problem, but how do I do it? I can generally talk, some conceptual relationships, some high-level steps on how to do it, and I talk about its value. I would say this left column is the stuff that sales pitches and all these sorts of things, right? But what's the invention? Not only have I identified a problem, I have a solution, right? Not only can I discuss it or articulate it in general terms, I could also do it explicitly with more facts, more substance, right? Not only do I have high-level steps, I have detailed design steps because I've done some development work. Okay? Not only do I have general sort of expectations of how this thing is going to work, I have defined, have a pretty good sense on the outcomes. What's the difference between an idea and an invention? One word, substance. You have to have the substance. And not only is that important in business, it's important when you try to get IP protection around. I can't just say, okay, I'm going to file a patent on curing cancer. The patent office will take my money and laugh in my face, and I won't get a patent on it. That's just how it works. So here's some strategy tips. And before any sort of public use, and this will start transitioning into the last part of our pitch, which was really going to be on communication. For any sort of public use, right, talking about it, writing about it, so on and so forth, exposing others, trying to sell it, file as comprehensive of a patent application as possible. Your protection starts when you file a patent application, okay? But your work isn't done then. Continue to keep up your research, your documentation, and so on. And if necessary, there's ways to speed up the review process, what we call prioritized examination. This is the prioritized examination. So the patent office gets it, and they put you in front of I'll say a fast lane of reviewing or examining, but you have to pay a little extra for it. And you'll always get a sense of what your competitors are doing. Again, every single day, new patents are being issued, and every single day, new patent applications become published. Again, if I file a patent application today, it's not going to be public record or in a public domain for 18 months. So new things are always coming out. So you got to stay up on it. Really quick, remember what patents do and what they don't do. Patents are an exclusionary right. It's the right to exclude others. Okay? That doesn't mean that you have the right to practice it, though. So there's this process called freedom to operate, where once you file the patent, once you've developed your product, and before you put your product in the stream of commerce, i.e. put for sale or this or that, just make sure you have your team just have a look to make sure any new patents that you weren't aware of by your competitors is out there. Okay? Patents differentiate your products because they're exclusive. Everyone likes to be, as part of the exclusive club, right? Patents gives you that exclusive club. Talk real quick about communication, and then hopefully we'll have some time for Q&A. So here's just some common mistakes we've seen over the years, and this is not just related to intellectual property. This is just related to legal in general, and hopefully you'll never be involved in lawsuits and these sorts of things, okay? In any sort of communication that you have with yourself, your organization, or whatever, particularly in the business context, avoid using terms like infringe, copying, bribes, stolen, and obvious. Why? Even though these words are used commonly, they have very, very strong meanings from a legal context. And if you're in a legal dispute and you get sued or you're suing someone else, one step in that process is called discovery. During discovery, the other side goes to the court and says, I need to see that person's emails. I need to see that person's documents. And if the court agrees, they're going to be able to get this trove of your documents, stuff that you wrote down. Sometimes it's even electronic information. And if they see those words in there, they're not going to interpret those words the way you intended. They're going to interpret those words in a way against you. So unless the communication is under attorney-client privilege, just be really careful. Even though some people do this knee-jerk reaction, they're emotional and all these sort of things, they're upset, blah, 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 they fire off these emails. You probably don't want to do that. But why is this so important? It's important because when you look at fairly recent case was Apple versus Samsung. Maybe you heard about it. If you research that case, right, Apple sued Samsung for patent infringement. Samsung said, no, we didn't infringe. Samsung had all these so-called experts. The jury didn't listen to the experts or didn't take the experts' ruling. What the jury gave weight to was Samsung's own internal emails, which said, quote, the new iPhone design is easy to copy. That costed Samsung about north of $1 billion in damages. That's why it's important. So what if you have a patent of concern, right? Number one thing, discuss with your IP counsel. Hopefully it should be a registered patent attorney. Just say, hey, you know what? I think this patent covers something I created before. What can I do? Or will this patent stop me from doing what I want to do? Verbally, right? Again, never put an opinion, particularly if you're not an attorney, in any writing, an email, WebEx, Connect, paper, or whatever. So if like we have a problem here, I think this infringes and so on and so forth, like, just don't do it. Because there's ways that you could handle this. You might be able to invalidate the patent, you might be able to get a license, you might be able to design around it and so on. Consult your IP team if you have questions, okay? Real quick, if you have documents that you're going to share externally, what should you do, right? Have it reviewed. Hopefully you have a marketing team or a legal team or a technical team. Is the content itself protected by a patent? If not, can it be? And if your organization has any sort of data classification, make sure that's used. And always, if it's going to be shared externally, just put a copyright notice on it. Copyright, blah, 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 2017, so on each page. And figure out if there's a non-disclosure agreement that should be in place. If you're sharing documents with customers, again, same sort of review process, but at a minimum, have legal do the review. Ask those same questions. Okay, when in doubt, ask legal counsel. And here's just a one-page guide, and these slides we'll be able to share with the audience. Okay, this whole pitch. Ask yourself a few questions. Okay. Is it going to be shared externally, the document? Is it going to be shared with a customer? And the reason why I make that distinction is because usually with customers there's already some sort of non-disclosure agreement in place. Should you have a non-disclosure agreement or some sort of confidentiality agreement in place? Add a copyright notice if it's going to be shared externally. There's another aspect of it, what we call proprietary notice if you're sharing it with the customers, which essentially says, look, we're sharing this information with you. It's only going to be with you only. You're not allowed to share that with others without our okay. So that's all I have. I think we have a few minutes for questions. And hopefully, I hope you all find this information useful. It's just a way to give service to, as an alum, to the RIT community. Thank you.
Thank you, Dale, very, very much. You got a big kudo with this presentation is excellent, with lots of exclamation points. And
did you say that, or someone really wrote that?
No, someone really wrote that. And they definitely are interested in being able to actually get your slides. So thank you for offering those.
Sure.
There is a question that has come in. How much? I'm not sure. I might want to reword this. How much difference if you're going to improve on something, does there need to be so that it might be patentable? That's a great.
Yes, I understand. That's a great question, and this is where I have to put my legal hat on. And the famous two words that you always hear lawyers say, it depends. I would say that if you're looking to get a patent, okay, if in the patent claim itself, the original patent covers A, B, C, and D, right? If my improvement adds a new element, so A, B, C, and D are 4 elements, right? Think of a chair and a rocking chair, for example, okay? The original patent covers a chair. You have a back, you have a seat, you have arms, and you have 4 legs. That's the original patent. Now, if my idea is to take that same chair and to put 2 rockers under the legs, I just created a rocking chair. I could get a patent on that rocking chair, right? The person who has the chair, they still have their patent. Where it'll get tricky with these improvements is, for me, if I wanted to sell a rocking chair, okay, I have to make sure I have an agreement with the patent holder of the chair itself, okay? Because to practice my patent, to sell my product, I have to do their product. However, what I may be able to do is just sell the rocker separately. So here's a rocker, here's a little retrofit kit that you could use on any chair. Hope that answers the question.
I didn't ask it, but it sounds like a good answer. Another question, how does someone who thinks they have an invention that could be patented get started? Is there a do-it-yourself kit? Do you need to go to an attorney? How does one just kind of get going on that process?
That's a very good question. We get that question a lot. And before I say what to do, I'll just kindly advise what not to do. And if we have time, I'll give you an example.
You have time.
So when I was in private practice, I got a client. Now, I was new. I was very young. I was only in private practice for a few years. So a partner gave me this client. It was a professor at UNC Chapel Hill. So I thought the partner was really doing me a favor, and he was. He was. But the person was a biology professor at UNC Chapel Hill, came up with this idea. And unfortunately, instead of going to an attorney or a patent agent, this person called one of these numbers that you see on TV, okay? And I don't want to disparage any organization, but there's a lot of these things promoted on TV, okay? Person spent $6,000 and got back some marketing materials. That was it. Didn't get any patent protection. The person thought they had patent protection. Then they wanted to create this product, and they got some investors. And the investor said, okay, let me see your patent. The person showed the marketing materials. They said, you don't have any protection here. So went back to that company that gave marketing materials. Oh, no, if you really want to get a patent filed, you're going to have to pay us another $10,000. So the professor said, no, I'm done with you. Okay. Now, the professor said, I need help. So the professor went to another one of these another one of these companies, because there's a few out there, explained the situation, and they said, oh, we'll take care of you, blah, 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 blah. Okay. But it's going to cost you $8,000. Professor ran out of money, went to their religious organization, made a pitch, got some investors, paid $8,000 to company number 2, and got even more marketing materials. Now, by that time, the investors want their money back plus their return. The professor didn't know what to do, came to me. And unfortunately, I couldn't help the professor. Here's why. Like I put in one of my slides there, the professor went ahead and publicly disclosed that invention to groups of people without having any confidentiality agreement in place. When you do that, and time goes by, more than a year, in most instances, you've dedicated that to the public. So what I would say, if you're a single inventor, or you want to just essentially try to go it on your own at first, there's a lot you can do yourself. I go to uspto.gov, okay? They have an excellent section on solo inventors, single inventors, what you need to do step by step. If you want to just search and you want to get a sense of what patents are out there, Google Patents is an excellent and free resource, okay? USPTO also has a pretty good search. So those are a few things I would do. Once you realize that maybe you're onto something, then the U.S. Patent Office also has a listing of registered patent attorneys and patent agents that you can search in your area. That might be a way to find somebody.
Thank you. What if you currently hold a patent and you have some suspicions that perhaps there's been infringement. What's sort of the process, and how do you kind of do that due diligence before you kind of take a leap of not knowing what you don't know?
Excellent question. I would say you want to be able, if possible, depending on what your product or service is, right? Any sort of way you could reverse engineer what's out there in the marketplace. So, for example, if I have a pen, I have a patent on a pen, and my good near-do-well friend Leslie is also selling pens, okay? I would get a hold of the pen, I would measure it, I would compare it, and just from a technical perspective, I would say, is this what's covered in my patent claim, okay? If that's the case, I would send a letter to whoever it is that's selling the pen. Why? What that does from a legal perspective is puts them on notice. Once an alleged infringer is put on notice and they continue to allegedly infringe on your patent, now they're doing what's called willful infringement. And if you win in court, your damages will be triple. We call it treble damages. Because sometimes people may infringe on your patent because they didn't even know your patent existed. So you got to notify them. But if they're notified and they continue to do it and they basically blow you off, then the courts don't like that and they could be treble damage. So the first thing you want to do is gather as much information as possible. And then if you still feel that's the case, you could send them a letter. But at that stage, I would probably at least consult with a patent attorney to get a sense of, okay, what should I do?
Thank you.
Welcome.
We are very close to the end, and I don't see any questions as of right now. So I will thank Dale for his very, very informative presentation, and thank all of you for joining, and let you know that I know this is a complex topic, and I'm sure you might have some questions that will arise later. If you do, please email them to ritalum@rit.edu or tweet them to @RIT_alumni with the hashtag #MeRITWebinars, and I, Cindy Silbright, will get those directly to Dale and get some answers back to you. As a reminder, Dale offered his slides, so we will make those available, and we will also make the recording of today's webinar completely captioned available via email within a week. Be patient with us. It takes some time to get the transcript back from our captioners. Again, Dale, thank you so much. Sorry the weather here in Rochester is very, very cold, but it is sunny. So all of you alums who remember your fond days in Rochester, we're at the light at the end of the tunnel here from the winter perspective.
Spring didn't start yesterday, though.
It did start, and we're a little behind. Again, thanks to everyone. Thanks to Dale. And our next webinar is in 2 weeks. Please join us. If you've got children and you're thinking of sending them to college, any college, not just RIT, join us for planning for your child's educational expenses. Tips and tricks on financial aid and scholarships that are available. Again, your child does not have to be coming to RIT to participate in this webinar. Thank you again for joining us. You can exit the webinar by closing your WebEx window, but please let us know what you thought about today's webinar by taking a very brief survey, which will pop up when you exit. Thanks so much, and have a great Wednesday.